All rise. Hear ye, hear ye, hear ye. The Colorado Court of Appeals is now in session.
Be seated, folks. Good afternoon. Welcome to Division 4 of the Court of Appeals. My name is Judge Ted Tao. To my right is Judge Bob Hawthorne, and to my left is Judge Steve Bernard. Together, we are the division assigned to hear the matter set on the docket today. We do have one case on the 2 o'clock docket. That case is 17CA2204 in re Marriage of Nielsen. I see the attorneys are present. You should by now have received a handout regarding our procedures. Do either of you have any questions about those procedures? No, Your Honor. While we will likely refer to attorneys as counsel, we may at times use names of counsel or parties. If we mispronounce any name or refer to someone by a gender pronoun different than the preferred one, we do apologize. Please simply correct us, and we will endeavor to get it right from then on out. Please remember that the arguments are being live streamed on the internet and will be archived, so if there is sensitive information, please take care in how you discuss such matters. On that note, if anyone in the courtroom has a cell phone, please make sure it is turned all the way off, not just silenced. This will not only ensure it does not interrupt us during the proceedings, but also will prevent the signal from interfering with the streaming, which can sometimes happen. Each side has 15 minutes for argument. Counsel, you will be responsible for managing your own time, including reserving time for rebuttal. With that, let's begin.
Thank you, Your Honors, and good afternoon. My name is James Vaughters, the attorney for the respondent appellant, Laura Jean Patron, in this case. Before I begin, I'd like the court to know that my coach for today is my grandson, Charles Vaughters, who is interested in the law and the courts and wanted to see this proceeding this afternoon. This is our fourth attempt to account for the negative $18,000 of equity that was in the family home at the time this marriage was dissolved. That was in the summer of 2015. The first time was a trial, second time was the first appeal, third time was on the remand, and this is now the fourth time. The central issue in this case is a one-liner from one statute, it's Colorado Revised Statute, Section 1410.113.1b. That statute enumerates the factors for the courts to consider in disposition of property. The one that's critical here is, and I quote, the value of property set apart to each spouse, unquote. That statute does not specify whether that means gross value or net value, whether it is something agreed to by the parties or something that was litigated, or even who gets the piece of property. It simply says the value of the property set aside to each spouse. And our position is that this $18,000 of negative equity, while it was mentioned one time by the trial court in its first orders, has never been dealt with effectively since then.
Mr. Vaughters,
Yes,
may I
sir.
interrupt you? I just have a well, it is a factual question. Throughout the briefing, everybody's talking about the negative equity. And I want to make sure, and I couldn't tell from the briefing and specifically from the record, the negative equity is created by a debt against the, I'm asking a question here. Is it created by a debt against the property which exceeds the value of the property? Is that correct?
Yes.
The mortgage on the property is $18,000 more than the value of the property.
That is correct.
So the property has a value. Have the parties agreed on the value of the property, not taking into account the mortgage or the debt, but what the value of the property is? The fair market value of the property.
I assume that they did because they agreed at the final hearing that my client would receive the property and that it had equity of minus $18,000. I believe that they got the figures on value from tax assessments at the time, and for the mortgage figures, got those from the most recent figures from the mortgage banker.
Okay, well, then my next question is, if I remember correctly, there was an indication in the, I think it was the court's order, that the parties' debt was equally divided. Is that correct?
That statement is correct, but those were debts aside from this mortgage. Those were personal debts, credit card debts, living expense kinds of debts, largely to their parents. And this court said that in its first order. That debt statement did not take into account the mortgage, so as best I can tell.
Pardon me for interrupting, Mr.
Yes, sir.
Waters, but to piggyback on Judge Hawthorne's question, I don't understand what you just said in light of what the court wrote. If I may read it to you, please. After review, the court concludes that the prior determinations regarding marital debt were based upon the evidence at hearing and that the debt distribution was equitable, and the analysis set forth above does not alter such conclusion. I don't understand why that also, if we're talking about debt on the house, I don't understand why that also doesn't include debt on the house, because the debt on the house was determined in the prior proceeding.
It's always been my understanding that that paragraph you read, while it's accurate for all the other debts, I saw nothing in the record that indicated that that statement took into account the debt, the mortgage against the house. It might have been implied somewhere, but I don't think anyone in this case has ever dealt with it as if that were the case.
Well, was the mortgage on the house ever specifically dealt with in permanent orders? Was there an order by the court that said, and I'm going to allocate the debt on the house to the wife because she's going to receive the house? Was there a specific allocation of debt as to the mortgage on the house?
Yes, there was. She agreed to keep the house, and she agreed to be responsible for the mortgage. And the court approved that agreement and went on from there.
Okay, so she agreed, as to just what you said, she agreed that she would take the house and that she would also assume the debt.
That is correct, yes.
Okay.
My problem with the orders as they've been entered, and this case has been dealt with over the years, is this: there's nothing that indicates, nothing in the statute or in any case, and I didn't cite any such case but didn't find any, to the effect that a party agreeing to receive a piece of property and to be responsible for that debt, that agreement takes that piece of property out of the equation, so to speak. The parties could agree to anything, and they did agree to this, and the court approves that agreement. But that didn't remove it from the statute that says the court shall consider the value of the piece of property. And what I don't see in orders anywhere is where the trial court ever considered the value of this piece of property other than saying, okay, the wife gets it and she's going to pay the mortgage.
Mr. Waters, help me understand one aspect of your position. It seems that you're saying that unless the ultimate distribution is 50-50, then something wasn't considered.
I'm just arguing for 50-50. The term equalization is often used. I'm not saying it has to be equal. It can be anything other than 50-50, and very often is.
So if the trial court essentially treated considered the negative equity, but didn't consider it to be something that needed to be put on the spreadsheet because perhaps the value of the home is subject to increase later or something like that, which is mentioned in the briefing, is that consideration of the factor or of the value?
What I've never seen in any of the trial court orders either time around was a statement to the effect that the value of this house has been considered by the court in making its distribution. This court, in its first order some years ago, mentioned the marital home 1, 2, 3, 4, 5 times in its orders, and the trial court made a passing comment to the home in the first order, saying the wife gets the home and she's to pay the mortgage on it. The second time around, the trial court didn't even address that at all.
Well, excuse me,
I'm
Mr.
sorry.
Waters, but I'm going back to your statement that the wife agreed to take the house and agreed to assume the debt, the mortgage. And the way I understand it, you were saying that's improper. The court can't rely on that. Wouldn't that be similar to the wife stipulating that the property division is equitable in her opinion if she agrees to take the house and she agrees to assume the debt in light of the other property division that the court has ordered? Wouldn't that be a stipulation that this entire property division is equitable?
I think not, but only because of the sequence of events. My understanding from the transcript of the trial is that that statement that she would take the house and be responsible for the mortgage was done right up front, long before the trial court, after the day of trial, made any decisions about how to divide the other pieces of property and what their values were. So she really wasn't stipulating that I'm taking this piece of property in light of the decisions and agreements for the others, because those had not been decided yet, had not been done at all. The trial court in the first order, and I thought this was significant, I did mention it in the brief, in its first ruling back in 2015, said this kind of thing: if I find that the assets of the marriage, Mr. Nielsen may get are valued at $100, and the assets that Mrs. Nielsen gets are valued only $50, I believe by statute I'm required to somehow equitably distribute those assets, which may include having an equalization payment. And I think that's absolutely within my role and my authority and my obligation to do that, unquote. Where that became significant, I think, was in the Court of Appeals' first decision, where it said right up front, it's on about page 2, by our calculations, we see that the husband got the business valued at $25,000, and we see that the wife got assets valued at $515. The way they got that number was the negative equity in the house, the $18,000, and then a positive of $16,000 in the retirement account and $2,500 in the camper. By writing that kind of wording, I think the panel was saying, by its very numbers, that's clearly inequitable, and we're inviting the trial court to go back and revisit that.
Pardon me, but the panel never said that,
I'm
Mr.
sorry.
Watt. Pardon me, but the panel never said that that was inequitable.
That's true.
They never said it was inequitable.
No. But by putting the numbers in there, surely there was some significance to that.
How about us simply recognizing the facts of that's the way that the cookie crumbled? I think it's pretty dangerous to read in some sort of inherent suggestion
Understand.
that they thought that the division was inequitable if the division didn't say so.
Sure. But that panel did say in 2 different places, we're remanding for the court to consider an equalization payment, and we want the court to reconsider the overall property division, which I think was asking the court to look again at this question of equity in the house.
Again, being careful with the phrasing, I don't believe the division said we want the trial court to reconsider. They left it to the trial court's discretion, did they not?
I'm sorry, Judge, I didn't hear all that.
You said in your paraphrase that the previous panel in Nielsen 1 said we want the trial court to reconsider the property division. What they said was we'll leave it to the discretion of the trial court if, after addressing what we're remanding for, that the trial court feels reconsideration is appropriate. It's in the trial court's discretion, correct?
That's correct.
So how did the trial court abuse its discretion in this instance?
The record contains no indication anywhere that the trial court ever addressed this negative equity in the house in making any decision about the division of property. She never said anything about it one way or another. I know that Mr. Martin in his answer brief said, oh, this has been argued and covered, and it was considered by the trial court, but I respectfully submit that the record doesn't show that the trial court ever did consider that at all. She very well may have. She may have been thinking it, but we don't see on paper that she ever did. The last order made no mention of the home, didn't mention its status as a marital asset or anything about the negative equity, didn't even say that there was a marital home to be considered. And I think that it's up to this panel to, for lack of a less strong word, to instruct the trial court to revisit the property division, and in doing so, to make specific consideration of that negative $18,000 equity in the marital home. However it's done, and whatever she does with that, however she may choose to deal with that, but to leave that piece of property over in this category and then go through and say, okay, the other assets we're going to, or the assets we're going to divide are the business, the para, and the camper, and not even acknowledge the house, I think was wrong and a mistake on the part of the trial court.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. My name is Brett Martin. I represent the appellee, Mr. Nielsen. And I actually represented Mr. Nielsen throughout all of the proceedings, through the dissolution in both Nielsen 1 and now Nielsen 2. The trial court on remand did not abuse its discretion. In fact, it's quite clear in the order dated November 15th, 2017, specifically the order regarding post-appeal matters by the trial court judge who presided over the final orders hearing. The judge specifically indicated that she took into consideration the transcript of the entire final orders hearing, which included the marital property, the brief submitted by both parties in Nielsen 1, the previous panel's opinion, and the trial court final orders - financial matters, as well as all exhibits. The marital property was in play throughout the entire final orders hearing. It is true that the parties stipulated that Mrs. Nielsen would retain the marital home for purposes of proceeding through the final orders and ultimately after final orders. However, the court, well, first and foremost, Mr. Nielsen then waived any opportunity that he would have to an increase in value of that particular piece of property. And to argue that the trial court did not take it seriously and seriously consider this situation is far from accurate. In the original final order, in the section under real property, the court specifically references the marital property, indicating that it has a negative value of approximately $18,000, and each of the parties agreed that respondent may remain in the home and retain the home if possible. Ultimately, the respondent was to sell the property, but the court even went a step farther, which quite frankly, we should credit the trial court. The court specifically indicates the court retains jurisdiction of this issue to address any deficiency if the sales proceeds are insufficient to retire the mortgage debt or in the event that the property goes into foreclosure. At no time has the appellant raised that issue with the trial court, indicating, wait a minute here, I took this property, perhaps I made a mistake. The trial court even gave her the opportunity to revisit the issue. It's never been revisited. There have never been any motions filed at the trial court level. There's never been an allegation set forth by the appellant that at some stage over the course of the last several years that she was stuck with effectively an albatross. So one can safely assume that the home, the marital property, appreciated in value. Otherwise, why would not someone have raised that issue? In fact, it probably increased beyond the debt amount. We've never heard.
Pardon me, counsel, but just like we need to hold your opponent to what the court actually said, you're speculating now, and that's not in the record.
Okay, I'll refrain from doing that.
Thank you.
I apologize.
And counsel, while we're there, let me ask you a similar question that I asked Mr. Vaught, and you were referring to the court's November 15, 2017 order.
That is correct.
And in the, I guess it would be the penultimate paragraph of that order, she says, after review, the court concludes that the prior determinations regarding marital debt were based upon the evidence at the hearing. The debt distribution was equitable, and the analysis set forth above does not alter such a conclusion. And as noted by the Court of Appeals, the district court did not abuse its discretion in dividing the marital debt equally. Therefore, the court declines to redistribute debt. Does that mean what it says? Did the court divide the marital debt equally when it left or allocated to wife the $18,000 or more than that, the mortgage on the house?
I don't think that it was allocated equally. However, the appellant elected to take on that additional debt, recognizing that there could be an appreciation in the property and that Mr. Nielsen would not benefit from that. And I
Mr.
think,
Martin, if I can interrupt on that
Certainly.
point. Let me change the hypothetical a little bit. Let's say parties are in the midst of a divorce and one of them owns a collector's vehicle, very, very precious vehicle, marital property, but clearly it's, let's say, it's wife's passion, not husband's passion, and they stipulate, you know what, she can have that, I'm not going to fight for that. Is that necessarily an agreement that that $100,000 value doesn't show up on the spreadsheet?
no.
So if wife in this case says, I'll take the house, I know it's saddled with debt, I'll take it. Is that a stipulation that the negative value doesn't show up on the spreadsheet?
No, it's not, but
And did,
Sorry.
in this case, the negative value ever show up on the spreadsheet?
I don't think the negative value showed up on the spreadsheet because the court was informed of a stipulated amount of the debt. The court was aware of it, and the appellant agreed to go forward by way of stipulation to assume that debt. But I think that it's not analogous to the car in my eyes. And the reason why is this. If the car has a specific value, it's an asset. I have this collector's edition car, it's worth $100,000. And I'm just going to let the other party have it and move on down the road. This is a different circumstance because what we have here is a property that arguably will appreciate in value. The car may or may not, it's an asset. And the court took the extra step to protect the appellant. In the case that it did not appreciate in value, the appellant could come back to the trial court and state simply, I made a mistake. I should not have done this. The house hasn't appreciated in value. I'm still in the hole, effectively speaking, $18,000, and I would like the court to amend its order. And the appellant had the opportunity to do that and did not do it. So we can't speculate about what did happen after the fact, but by default, one would assume that that is the case, because there was a mechanism set in place by the court to continue jurisdiction over that marital property in case the appellant suffered economic harm.
Is there a legal basis for reserving jurisdiction on a property division once it's established?
I think that the court can maintain jurisdiction over it as long as the parties don't dispute it. So if you agree to that, I have done that in the past In similar circumstances where the parties own a parcel of property and it's increasing in value rather rapidly, you can carve that off and allow the court to maintain jurisdiction over the property for a period of time as long as it's agreed upon by the parties. And in this case, no one disputed it. My client didn't object to that. Quite frankly, the intention here was not to leave the appellant in a state of financial distress. On the contrary, it was to let her remain in the home with the children in the anticipation that it would increase in value and that there would not be any debt associated with it, hopefully a profit. Of course, that is not pertinent for purposes of this argument. I would also, pardon me.
I hate to interrupt you again.
That's quite all right.
But I want to follow up on Judge Tao's question about what was on the spreadsheet. And we're talking about the financial affidavits, I assume, as that both parties submit. Was the house ever listed on the spreadsheets with a value? It's worth $300,000, or it's worth $325,000 or $250,000 or whatever. Was there a value listed on the spreadsheet? And concomitantly, was there a debt listed on the spreadsheet that was submitted to the court? Is it in the record? What's in the record?
Well, and that's referring back to the sworn financial statements that the
Yes.
parties are required to exchange and disclose. I'll be quite frank, I haven't looked at a sworn financial statement in this matter in quite some time, but I will represent this to the court. I represented Mr. Nielsen at that time, and there's a specific section in the sworn financial statement that's utilized by all parties in dissolution proceedings in Colorado, where you are required to put in an approximate or estimated value of the home if you don't have an appraisal that's recent, and any debt associated with the home. So I can't say definitively because I haven't seen that in probably years, but I would, not to use the word assume, but it would be a normal course of business to include that information in the sworn financial statement.
Okay, what I'm trying to find out is, was the trial court aware of those figures at the time permanent orders was originally entered? Or was the trial court only aware that with regard to this marital home, there's an $18,000 negative equity? Not knowing what the values of the home and the mortgage were, but just that there was a negative equity. Do you know which way that was?
I understand the question. I don't want to answer it definitively because I don't have the document in front of me and I didn't review it prior to this, today's proceedings. All I can simply state is that when one fills out a sworn financial statement, which Mr. Nielsen did, and as well as Mrs. Nielsen at the time, I can't fathom a scenario where one would leave out the marital property. It's really the only significant asset that they had. So it would have been the focal point of the sworn financial statement, as well as all of the associated debt that the parties accumulated prior to and during the marriage.
Thank you.
Bringing it a little, sorry, Gary.
I'm sorry to play ping pong with you.
That's quite all right.
I am curious about what Nielsen 1 means to this particular issue. Under the equalization payment section of Nielsen 1 that says the court should reconsider and remand whether an equalization payment is appropriate, it also has this sentence, two sentences. To the extent that wife argues that her retention of the marital home is unfair, she agreed to keep the house at its decreased value as she conceded at oral argument. Accordingly, she may not now argue that the property division is inequitable on that basis. Is that the law of this case? And if so, does that apply to this particular issue that we're talking about today?
It does, quite frankly. I think the first panel resolved this issue. In my interpretation of the order, I frankly thought it was quite clear, and that the issue was resolved, and that it was not to be revisited, but here we are. I firmly believe that the opinion of the first panel set forth the parameters that the trial court was to use on remand. It was to consider an equalization payment. The trial court did so. That involved primarily a car that was not marital property, that was arguably not to be in that division of debt and assets. The appellant was compensated for that, and she kept the home. And I do think that there was no abuse of discretion whatsoever on the part of the trial court in its second order. And I do think also, and this court is aware, that in Ray Lodholm specifically allows the trial court broad discretion, and the mandate to distribute property equitably does not require equality. And this is a circumstance where Your Honor said earlier, well, maybe that's just the way the cookie crumbled. Well, that's the way it crumbled. We had significant time in trial, both dealing with the family matters as well as the property matters. All parties were provided ample opportunity to present all the evidence that they needed to do, and the trial court did a very effective job. So we take the position, the appellant does, that the previous order of the court controls, that there should not be any additional distribution of debts or assets in this matter, and to consider the matter closed.
Mr. Martin, didn't the original panel explicitly take into account the negative equity in those figures?
The panel did. It
And doesn't
acknowledged-
that disappear now?
It doesn't disappear. It's just simply that if the panel takes into consideration the negative value, it doesn't have to be brought up again on the trial court's order. The trial court specifically said that it went back and reviewed everything, both the transcripts, everything from the first final orders hearing, as well as the Court of Appeals opinion in Nielsen 1, and used its discretion to decide what was an appropriate distribution of debts and assets, and it did so. I don't see that there's an abuse of discretion there at all. In fact, I think the trial court was acting well within its means at the time. And it did, even though, as Mr. Vaughters has stated, there's no mention of the marital home. Well, the bottom line is there is mention of the marital home, because if one goes back through the entire record, all of the briefs, the order in Nielsen 1, or the opinion in Nielsen 1, it is referenced.
Forgive me, but I don't think the issue is really the home, it's the negative equity value of it. And here's my concern. In the post-remand order, the trial judge essentially does the math, and in doing that math, never accounts for the negative $18,000, and yet clearly intends to equalize. Then in the next paragraph says, I've divided the debt equally, but she hasn't, has she? Because if we're talking about the personal debt, that was divided equally. She doesn't say equitably, she says equally. But that mortgage, it seems to me there is a danger that the mortgage was treated as part of the asset, but then ignored when doing the math, not treated as part of the debt. So when she decides not to readdress the debt, she's not readdressing the mortgage, but when she addresses the assets, she forgets to address the mortgage.
Well, I think taking the position that she forgot to do it is something that myself or the panel really can't come to a conclusion on, because we don't know whether it was forgotten. One could just as easily assume that she took it into consideration but simply didn't state it in the order. Due to the judge's familiarity with the underlying facts and all of the assets and debts, I just would find it very surprising that it wasn't part of the equation that she used in order to arrive at what an appropriate equalization payment was. But once again, that does call for speculation. If the wording there, and I agree with you, Your Honor, it does say equally, and there was not an equal debt division, because the debt associated with the home was carved out by way of stipulation between the parties. If the panel requires additional clarification, I would simply ask that it be remanded back down for further clarification from the trial court so that we can get an answer as to whether or not that was taken specifically into consideration upon arriving at the second order. I don't think that that's inappropriate. If there's any uncertainty, that would certainly clear up matters. But once again, I do think that the ongoing familiarity with the court, I just would be very surprised if that wasn't taken into consideration.
Thank you, counsel.
Certainly.
That is your time.
I'm in the red, so do
Yes.
you want me to stop?
That's my fault, but
That's okay.
your time is up.
All right.
And Mr. Vaughters, since I did essentially grant him a couple of extra minutes in response to that question, if you have anything you want to add, I will add a minute and a half to your time.
A couple of minutes?
A minute and a half.
I appreciate that. I didn't reserve that time.
I understand, but because of my question, he ended up with a little extra time, so in fairness, you should have just a little bit extra time.
That's fine. During the discussion between Mr. Martin and the panel, I went back and looked at Nielsen 1, and I think and hope that on page 5, paragraph 18 of that decision, that the question about debt can be answered. It says that each had debts of about $40,000 made up of family loans, and the majority of the parties' debts were incurred during their separation. Therefore, we conclude the district court didn't abuse its discretion in dividing the marital debt equally. I think in context of that paragraph, marital debt, personal, incurred during their separation, I think all of that leads to the conclusion that the mortgage debt was not included in that calculation. That may be up for grabs, and I don't want to speculate, because Judge Bernard will soundly chastise me for that. But that's as close as I can come to trying to answer that part of it, and I appreciate you bringing that up with Mr. Martin, and I hope that does help some. Thank you very much, Judge.
Thank you, counsel. Thank you both, counsel, for your excellent arguments. The case will stand submitted, and a written opinion will issue in due course. We will now be adjourned, and the bailiff may so announce.